Hi, my name is Arati Ganeshan and I'm a journalist at MediaNama. I'm delighted to welcome you all to the research presentations for the 2021-2022 cohort of the Meta India Tech Scholars. Meta launched the program to provide a research and mentorship platform to law students who are keen to engage with contemporary questions of technology, law, and policy. The law firm Shardul Amarchand Mangaldas Co is supporting the program as a knowledge partner. Through this series, the scholars will show us how specific policy choices in the technology sector influence and impact India's tryst with the internet. Today, we have Varunavi Bangia with us. Varunavi is a graduate of the West Bengal National University of Juridical Sciences. Her work as a Meta India Tech Scholar focused on conceptualizing a collective rights framework for algorithmically created groups through focusing on the need for extending the data protection framework to non-personal data as well. I'm delighted to have you here, Varunavi, and look forward to understanding a little more about what that very long sentence meant. So please take it ahead.
Thank you, Aarti, for that wonderful introduction. I do hope that whatever you mentioned in your introduction would be clearer by the end of my presentation. And I do hope that this is the sort of work that does influence policy in the future, because we really need to get to a place where the right to privacy that was envisioned by the Supreme Court in the Puttaswamy decision is actioned more realistically, keeping in mind the market realities of today's digital economy. I'll start sharing my screen and presenting the work that I did as a part of the Meta India scholarship. So hello all. As a Meta India scholar, I focused on the study of non-personal data and the need to regulate non-personal data by, by imagining a group rights framework in addition to the individualistic view of what the right to privacy encapsulates. The focus of data protection legislations across the globe has been the notice choice framework, which is premised on informed consent of the user. However, the algorithmic decision-making realities of today's digital economy force us to reconsider this framework, because the premise that knowledge is that the data principles or the data subjects are aware of the fact that their data is being collected or processed is almost no longer true. Therefore, this paper and this presentation attempts to shift the focus from a notice consent framework to a framework that accommodates the realities of today's digital economy. Now, why did I choose this topic? I think the word non-personal data is sort of something that intrigued me at the beginning, as to how can data that has been collected from humans and that is processed in a way to target humans be categorized as non-personal, and whether such neat classifications are possible or even workable. The presentation therefore focuses on both of these aspects, which is one, how is non-personal data characterized, categorized, and whether such categorization is enough while conceptualizing a data protection framework, and two, whether an individualistic focus of the right to data privacy is enough in today's digital economy. So the first slide talks about what essentially the scope of any data protection law has been in India and mostly even across the globe. Several jurisdictions have limited the scope of what constitutes data protection as any data about an individual who is identifiable by or in relation to such data. Therefore, personally identifiable information is the limited scope to which any data protection law applies. This scope, therefore, excludes anonymized data or what is often referred to as non-personal data. Now, the problem with this narrow exclusive domain of personal data is that it excludes a large chunk based on an essentially inaccurate anonymization process. Why I say anonymization is inaccurate is because there have been studies to show that social media profiles, for example, of people can be re-identified without a single piece of personally identifiable data. What that means is that you do not need any quote unquote personal data to re-identify any individual from anonymized data sets. And the reason for this is the huge amount of aggregation of multiple data sets that is happening in this digital economy. Therefore, raw personally identifiable data is of absolute no use to any data processor. What is of use as well as monetizing value to them is the aggregated data sets that are created by layering these anonymized data sets over either already anonymized data sets or personally identifiable data sets. Therefore, not only is anonymization inaccurate because anonymized data can be de-anonymized and re-identified, but it is also dangerous because along with this risk of re-identification, there is the risk of aggregating anonymized data, which leads to re-identification without any de-anonymization. Therefore, the scope of data protection cannot solely be identifiable data because that excludes an entire class of data that can be used to the detriment of data subjects. The second aspect of personal versus non-personal data is that non-personal data in aggregation with personal data is often used to draw inferences about an individual. And these inferences are of extreme monetary value to these data processors. Therefore, the logical consequence would be that these deserve protection as well, or at the very least, regulation. However, the current framework excludes inferential data from the definition of personal data. Now, the Data Protection Bill of 2021 did have a provision where inferences were protected as personal data. However, the most recent iteration of the bill, that is in 2022, excludes from within its scope any mention to inferential data. And if one refers to the first point of this slide, that is directly picked up as the definition of personal data from the most recent iteration of the bill. Therefore, we can see that this bill is a step backwards in trying to protect what essentially constitutes the scope of data protection of personal data and what would be the most apt way to protect the privacy of Indian digital citizens. While I understand that inferential data was something that was protected in the 2021 iteration of the bill, it is also important to note that that protection was seemingly limited. The reason for this is that inferential data was protected only to the extent that it related or was drawn from personal data. Therefore, if inferences were drawn from anonymized data, which is characterized as non-personal data, such inferences would not be protected. This, in my opinion, and as I have argued in my paper, runs counter to the idea of why we protect certain information. Personal data is protected not because it is drawn from other personal data. It is protected because it carries with it the scope of affecting an individual. Inferences relating to an individual should be characterized as personal or non-personal based on whether these can lead to identification of an individual and not the source through which these inferences are drawn. Therefore, the first recommendation that I have suggested is the second recommendation that I have suggested is that protected inferences should include inferences that are drawn from NPD, that is non-personal data or anonymized data, and inferences should be protected based on the nature of the inference, that is, whether it is personal inference or whether it's non personal inference, and not the source of data that is used to derive such an inference. And the first recommendation that I have suggested in my paper is that non personal data should be classified as human non personal data and non personal data. Now, what I mean by human non personal data is that while personal data has been seen as the subject of data protection laws, non personal data has often been seen as an economic resource of untapped potential. And that is the reason why both of these categories of data have sought to be protected in separate legislations or separate frameworks at the very least. However, we have seen through our previous slides that such a neat characterization of personal and non personal data cannot always be done. Therefore, the first need is to regulate both of these kinds of data within a singular framework. And the second important thing to do is to characterize them in a better fashion. That is, anonymized data or data that can directly, indirectly, or in conjunction with other personal data be used to identify an individual should be referred to as human non personal data. Because at its very essence, it is data that at one stage was derived from personal information of humans. However, not human non personal data, such as data that never related to a human nor was derived from a human, can be characterized as non human, non personal data. Therefore, both at the time of collection and at the time of use, such data is not relating to humans and may be used correctly as an economic resource of untapped potential. The next part of my paper talks about the collective rights framework. Now, why do we need a collective rights framework in addition to an individualistic framework? Is because the digital economy has moved far beyond monetizing an individual's raw data or processed data. The focus of data processors today is to create a digital framework where, where a more invasive and accurate profile of an individual can be created by categorizing them into several groups that can be targeted more directly. Therefore, our focus of protection must also shift from an individualistic lens to a more collective lens. An attempt was made previously in the non-personal data report, which was a group of experts who had come together and published a report and suggested the stewardship model of collective rights. Now, in this stewardship model, advocacy of rights is done by a person appointed by the group collectively as a quote unquote data trustee. Now, there are two reasons why this data trustee cannot work in the sort of framework, in the sort of realities of the digital world today. One is that the appointment of such a data trustee presupposes the ability of these groups to structure, collectivize, and organize themselves in a way such that they can appoint this trustee in the first place. And secondly, it assumes that socially created groups or pre-existing groups somehow coincide with these algorithmically created groups. And both of these presumptions are entirely false. Therefore, the starting point of regulation can never be belongingness to a pre-existing group. This is because when a person is deemed to be a part of a group by certain algorithmic decisions, they either may or may not know that they're a part of that group, or they simply might not know that such a group exists for the purpose of profiling. Therefore, there is limited ability on their part to collectivize in the first place to appoint such a data trustee, or to even collectivize at the secondary level to recognize what their rights are and what they deserve protection from. After therefore seeing that the traditional stewardship model of collective rights does not work, I propose a more modern way of looking at how these groups are identified in reality and therefore how they deserve protection in a regulation. First stage of identification is to look at the interest or purpose of creating such a group based on existing or perceived behavioral patterns and attitudes. Therefore, the first step must always be from the lens of the data processor and not from pre-existing membership by the data subjects. The second step should be the violation of that group's privacy as a group directly actionable as a consequence of being associated as a member of that group. And thirdly, should be to identify a remedy that individuals of that group should have when their rights have been violated solely because they've possessed membership to that group. In the Indian context, I argue that it is not very difficult to conceptualize a group data framework. And the reason for that is that scholars across the globe, while talking about group privacy, have often premised this understanding in privacy being an extension of a group's identity. Therefore, the focus of group privacy is that it shifts from considering privacy as a function of confidentiality and control over one's personal information to looking at privacy as a function of an individual's immunity from consequences of bias and discrimination through tools of social surveillance. In India especially, the Supreme Court in the Puttaswamy versus Union of India judgment recognized this need of linking privacy to an individual's identity. They recognized the they called for a statutory framework of informational privacy or informational self-determination, which acknowledged the harms of data aggregation. The judgment also focused on the fact that aggregation technology of today means that information in silos does not hold much significance from a market perspective. Therefore, harm of aggregation and of especially aggregating information that is personally identifiable or private in isolation is of no significance. However, once combined with swaths of other data, can create more detailed behavioral and attitudinal profiles of individuals. Therefore, all the way back in 2017, the Supreme Court had recognized that protection of raw or processed individualized data is of little significance. What is of more harm is the aggregation technology that this raw data possesses. This judicial roadmap, however, in India has remained a missed opportunity because statutorily we have not been able to capture the understanding of what the judiciary envisaged a right to privacy to look like in the data protection framework we draw up. However, there have been certain models that uh, have been tried in other parts of the world or have been argued by scholars where group rights can be identified. One of such models is categorical privacy. Categorical privacy applies to data that was originally identifiable, but after aggregation has lost its ability to identify an individual. However, it retains group identifiers. Therefore, as a consequence, it would have similar adverse impact on individuals who belong to such groups, even though they might not directly be identified by that data. Categorical privacy accords rights to these individuals as members of groups to agitate their rights similarly as they would agitate their rights as an individual whose data has been infringed upon. Certain ex ante measures have also been recommended. For example, in France, where the law in France seeks to regulate automated decision making in general. However, it accords rights to anyone who wants to access the source code of the algorithm, recognizing that the black box functioning precludes individuals from knowing whether or not they are being directly impacted by a certain decision. Such ex ante measures should also be reflected in other, more less mature data economies, and they should include impact assessment studies to check for bias and discrimination, and the ability of the data regulators to audit these algorithmic decision making and their impact on the society. With that, I draw an end to my presentation, and I hope that through my presentation, I was able to bring about a more clear view and a lens through which we should protect not only personal data, but also non personal data. And while extending this protection of data protection to non personal data, we must also see how group privacy or collective rights can be envisioned in a country like India. Thank you, Aarti. I'll stop my presentation now and
Yeah.
open the floor for any questions that you may have.
Thank you so much for this, Varunavi. It was really interesting. And I think also takes us back to the philosophical questions of what privacy is and when does it start to apply. Maybe in the olden days, 200 years ago, it would have been far simpler. But now I think the way societies and technologies are stretching concepts, none of those notions apply anymore. So it was really great to see how you've kind of teased out what this evolved concept might look like. I think what I was curious about, and this is just coming from a layman's perspective, is you kind of speak about group harm and harm to people, harm to individuals, privacy violations. I think for many of us, we're still not entirely clear on what privacy violations in this case actually look like when you're talking about inferences, when you're talking about group privacy rights being harmed. In the real life, what does that look like? Because I understand it from a personal standpoint. If my PAN card isn't protected properly, some scammer might hurt my finances. But how does it work in the case of group privacy?
Yes, that's actually a very interesting question, Aarti. Thank you for that. And I think the answer to that is also extremely simplistic, right? Because we don't live in a society where all decisions are necessarily taken with human oversight. There are decisions that are almost entirely delegated to algorithmic functioning.
Right.
Some of these include things that are very closely interlinked with our day to day functioning. If I can take an example of, say, getting an insurance policy or even getting a credit card, a lot of these decisions are based on information that is collected and aggregated and used to bucket you into certain several groups. For example, if there is payment or there is transactional history that is collected, they will try to bucket you into a person that has a higher propensity to not pay their credit card bills, for example,
Right.
and therefore offer you either a credit card that is either not of a very good limit, or maybe not offer you a credit card at all. These decisions often are not supplemented with any human oversight. Therefore, there is a need to understand A, how these decisions are being made, what are the factors that are going into it, and B, also looking at the fact that entirely aggregated data, for example, your payment history, it
Mm.
can be entirely aggregated, but it is still having an impact on decisions that are being taken relating to you.
Yeah.
And so there is where the right arises to have a certain knowledge of how these decisions were taken and the data that related to these decisions, whether it was protected or not, or whether it deserves that protection or not.
Right. So this is sort of again like a descriptive example, but I'm saying in real life, have there been documented cases where, something has happened to someone? Like, what does that look like in a real life use case example?
Okay, so I will have to look back and look more closely at how there have been instances in India where people have been actively discriminated against, or there has been an active bias.
Right.
But these cases are also hard to sort of find, because, like I said, algorithms are behind a black box, right?
Right.
So
Right.
there will never be an attribution of responsibility that this has happened directly in consequence of this. And
Right,
because there doesn't exist scope of protection, these are also often cases that are not, taken to court.
right,
Um, so I think that is one hard part of the exercise of trying to find this. But I think if we look at more in terms of the political context, for example, and thwarting of protests through drones
yeah,
or facial recognition technology. I think that is another case where we need to look at group privacy, because a lot of places, for example, increase their police presence based on geographical data that is collected, which is also on in the first place premised on bias, which is the ghettoization of certain urban places.
yeah,
And then police presence is increased in those places. Subsequently, it becomes harder for those people in or people in coming to those areas to protest publicly, again with respect to surveillance technologies that are applied to these people, not only by the state machinery but also by private actors who then share this information with the state machinery or the law enforcement. So I think it's sort of this entire cycle, um, where people get stuck trying to recognize or draw that clear line between what affects you and how. And the
right.
reason for that is most of these things lie behind a black box, and we don't really have very clear answers of how this decision came to be.
Right. And sorry, this is just an extra follow-up question, but you framed this in a sort of privacy context, which I understand. But when you're talking about the lack of algorithmic accountability, that ultimately to me seems a bit like a safe harbor question, like who becomes accountable, or like why is an algorithm, is a platform responsible for the decisions that it's making? So do you see an intersection over here? And like, is this just a data protection question, or is it also about, companies or, like you said, say an insurance provider, anyone taking accountability for the systems that they're designing that potentially put people at harm?
Yes, definitely. I think the questions of accountability and safe harbor as well as data protection have to go hand in hand. And I think one good thing that the government is doing in relation to bringing about the Indian Digital Act is
Yes.
that it's trying to regulate the entire digital economy through one legislation. And I think once we do see a comprehensive draft of that bill or any report relating to that bill, we'll be able to speak better on how that is being conceptualized. But I think in principle, it is a good idea to sort of understand that all of these systems work in tandem, and
Mm,
therefore they must also be regulated in tandem
yeah.
in order to avoid things like jurisdictional overlaps or procedural things that might come in the way of data justice to citizens who are seeking it. I think it's a good idea to regulate it all in one under one umbrella. So yes, I would agree with you that these questions of safe harbor would definitely intersect with the questions of data protection and the conceptualization of privacy in a more theoretical sense.
Right. Thank you for that. And just one last question, which is
Yeah.
essentially, we had the Puttaswamy judgment, which gave us, reaffirmed the right to privacy. And as you mentioned, the lack of a data protection law means that that right to privacy is sort of scantily protected in India right now. But have there been cases, whether in laws or in policies or maybe in sort of company practices that you've noticed where group privacy is actually being given importance or actually being protected even without the legal mandate to do it? Like, are people cognizant that this is an issue? And are they already trying to solve for it? Is I guess the question that I'm asking.
I think we wouldn't have to look too far. I think just judicially,
Mm.
after the Puttaswamy judgment, I think the Supreme Court used the verdict in the Puttaswamy judgment to sort of decide the Navte Johar case,
Yeah.
right? Where a group essentially got protection under the law and 377 was decriminalized. Um, Understanding that these individuals also have a right to privacy. So
Right.
although like in an entirely different context, not in the context of digital rights or data protection, I think um, the judiciary has constantly maintained the stance that privacy is not just an individual's individuals, right? It extends to people belonging to a certain group and recognizing themselves through a certain group identity. And I think that's also something that the Constitution underlies, right? Because
Yeah.
within our Constitution itself, the right to equality, as we understand it, is the right to equity or the right to equality for equal people.
Hmm.
And likes cannot be treated, unlikes should not be treated like, um, is also a constitutional principle where the Constitution itself recognizes certain increased rights for socially disadvantaged groups. So
Right.
I think group rights is something that the Indian Constitution has always recognized from the very beginning, and
Right.
so has the judiciary. So, like I mentioned in my presentation as well, we have an extremely solid foundational framework to actually implement a statutory conception of group rights in the digital framework. It just requires the sort of prioritization on the part of the legislature to push this through.
Right. Thank you so much for that, Varnavi. On that note, I think we come to the end of your presentation, rather. This was a really fascinating discussion, and like I said, to kind of sit at the precipice of what you're talking about and understand how rights are changing as the internet grows and ruins our lives. I don't know. Um, it was really wonderful listening to you. If you'd like to read more of Varunavi's work or any of the other scholars, please do visit the MediaNama website or our YouTube channel. You can find all of these interviews there and extra information as well. Thanks so much again, Varunavi, and look forward to staying in touch. Bye bye.
Thank you so much, Aarti. Thank you, everyone. Thanks a lot.